This honorable court is now in session. Please be seated.
Okay. Let's see, Ms. Toomes? You just stay right there for just a minute. I just want to make sure you've heard me discuss with the other self-represented litigants what your rights are and the procedure that we're utilizing. Do you have any questions about any of that before we get started?
Can I get an extra 5 minutes?
No, ma'am. No, ma'am. What we have is 15 minutes. But I understand your request, but that's what our normal procedure is. Anything else? Okay. Just, sir, you're not a party to this, are you?
No, but I'm her husband. I'm with her.
Okay, that's fine. That's
What
fine.
she meant was, could she get a 5-minute rebuttal? She didn't word it right.
Rebuttal.
Oh, is that what you mean? I'm sorry. Well, thank you for pointing that out. In other words, you get 15 minutes, but you'd like to reserve 5 minutes for rebuttal, so you'll have 10 minutes, then you got 5 minutes. Is that what you were asking?
15 minutes, you get 15 minutes, then you get an extra 5 minutes?
No, ma'am. You get 10 minutes, and then you'll get 5 minutes.
Well, after I talk, I can go back up there for extra 5 minutes?
You'll have 10 minutes initially, if that's what you're wanting, and then we'll hear from opposing counsel, and then you'll have 5 minutes to respond.
Yes.
Is that, you understand that?
Mm-hmm.
Okay, all right then. Why don't you come on up, and Miss Angie, if you'll call the case, first of all.
Sharon Toomes versus DNS Motors et al.
All right, and if you'll tell us who you are, those lights will come on, and you'll have the green light, a yellow light, and a red light. So when the red light comes on, you will have used your time. Any questions? All right, you may proceed.
My name is Sharon Newbern/Toomes. I purchased a vehicle from DNS Motors. Paid my sales tax, paid my down payment. I was paid up, wasn't behind and none of that. My truck was having some issue before the damage got done to the vehicle. They told me it was missing some plugs, all I know. I said, well, I'm gonna put it in the body shop, get the damage fixed first, the body damage. Then I worry about whatever's going on with the vehicle. They came down there, DNS Motors sent down there, somebody down there to get the truck. Now, I spent all my kids, I got 2 disabled kids and myself disabled. I spent all of me and my kids this stimulus money on this vehicle. I think it was $4,000 or $4,500 down on the truck. Put it in the body shop. He sent somebody to go get it. Said it was sugar in the tank. I never seen sugar, never discovered sugar in the tank. But I know it was running bad, so that's why I had it delivered to the body shop. They go to the body shop, get the vehicle. I'm not behind now. Get the vehicle, do what they want to do to it. Call the insurance. I called the insurance. I went down there to get it. Went down to DNS Motors to get the vehicle. He had it in a fence, locked up in a fence, with a truck identical to mine. I asked for him to release it. He said he wasn't going to release it to me. The insurance adjuster going to come look at it there. I asked him why. We got in an argument. I took it to court. I won in the first court. They said that they ruled in my favor because he didn't file the proper paperwork to retrieve it. He breached his contract and a lot of more things. I put it in the brief. They come telling me that I kept asking where the truck was. I didn't know where the truck was. And they I kept asking where the truck was. They would never tell me till after this last court date. It was down there at Coparks. So I called Coparks, sent me a letter saying if I want to get the truck, it's $3,000 to get the truck. I didn't take the truck there. They took the truck there. They took it from me. Went to the body shop and got it and took it from me. It was my truck, my problem, my business. I wasn't behind on the truck. You get what I'm saying? So he went and got the truck, saying he was trying to help me. How you trying to help me? I didn't know you had the truck. I didn't know you had the truck. Then they said sugar was in the tank. You didn't call me and say, Miss Toomes, you got sugar in your tank, or none of that. All this was done behind my back. I put the truck in the shop get the body damage done. Somebody took a sharp object and wrote all over the truck. They didn't let me get a chance to figure out what was wrong with my truck. I'm gonna get all that done. Look and see what's wrong with it. Whether or not, they said it need a motor. How I know that? You didn't let me see about my own truck. He called me, he asked me, he said, Miss Toomes, you all right? DNS Motors. I said, yes, I am. He was like, you and your kids all right? I said, yes. I said, what's supposed to be wrong with her? He like, you had some damage done to your truck. I said, yeah, but it wasn't done at my residence. It was done somewhere else. And then next thing I know, I called the body shop back again. I called the body shop to see how they got the truck ready. They said the man from DNS Motor came and got your truck. So I called DNS Motors, asked him why did he have my truck. He was like, the insurance people gonna come and look at it at my place of business. I said, well, you can get it pulled to my house and let them look at it. He said, no, I want it done at my place of business. All I want is my money back. My money, and then they making me pay for something that I wasn't behind on. And like I said, I wasn't gonna pay for it. I was paying for the vehicle. The people at Copart called me and said, Miss Toomes said, if you're gonna get your truck, you need to bring us $3,000 and you're gonna have to have a rollback. I said, why I had to have a rollback? She said, all the parts is taken off of it. You don't have no tires. She said, that convertible gone off of it. She said, it's a lot of parts gone out your vehicle. And I said, why are the parts gone out of it? She said, ma'am, this car been here 2.5 years. I didn't know where the car was till the last court date. They told me none of that. None of that. I was left in the dark. All I'm stressing, that was my vehicle. I wasn't behind. It was my problem. Anything had to do with something you bought as is without no warranty, it's your problem. It was my problem. If I chose to let it sit in my yard where I continued to make payments on it, if it needed a motor, if I chose to make payments on it and keep the insurance up until I can afford a motor, that's what I would have done. But they swiped the right way for under me. Just took the vehicle. And I'm lost on that. They're making me trying to make me pay $7,000 for something they took from me. When you sign a contract, when you purchase a vehicle, you're responsible for anything that happened to that vehicle. You is responsible. When they took it from me and he breached his contract, I was unresponsible for it because I didn't know where it was. That's what I'm saying.
Ms. Toomes, did you ever get an offer from your insurance company to total the vehicle and pay you $7,000 or $8,000 for it?
Yes, and he was gonna get and then another thing, I'm glad you brought that up. When you do a contract, you know, like you purchase something and they say, well, if you purchase this for 24 months, you gotta pay us like $2,900 interest. Okay, if you didn't have it for 24 months and you only had it for 2 months, the interest supposed to come off, right? He left the interest on it, and then they said that he would get all the money in the vehicle. He would get the money, get the payoff for the truck and the vehicle.
So did you accept that offer from the insurance company?
No,
So you didn't accept the offer?
no. Why would I accept?
They never paid you?
No, they never paid me. They said if they called me and explained it to me. They said if I accept that offer, David Peebles would get all the money, every last dime of it. And the interest should have been offered there, because I done had it 24 months. The interest should have been offered there. All them interest he had on there, it should have been offered there. I was gonna keep paying for my truck. If it needed a motor, I was gonna keep paying for it and keep paying, keeping the insurance up until I got my next stimulus check. Then I was gonna have a motor put in it. But they didn't give me a chance enough to do that. They just went to the body shop and got it. I never seen nothing or heard nothing like that. If you're not behind in your payment, you paid up. Sales tax paid, insurance paid, everything paid. Then you put it somewhere where they taking parts off of it. Took the tires off of it, Cadillac convertible, everything. Took it somewhere, then they're gonna tell me that I gotta pay them $3,000 to get the truck. $3,000 to get the truck, then turn around and pay David Peebles for the truck too. I don't have that kind of money. I only get $5 a month, disability. My kids only get $583 a month too. We don't have that kind of money. Now we gotta get on the transportation bus to get to wherever we need to go. Transportation bus. When we had a stimulus check and I bought a truck, my stepdaddy owned a shop where he fixed cars. He was gonna put a motor in there for me. He was gonna do all that, but they didn't let me get around to all that. They had dollar signs in their eyes. They wanted to say that the truck had this and that on it. So the insurance company can pay it off. He had dollar signs in his eyes. He wanted his money for the truck.
You've used your time, Ms. Toomes. You've got 5 minutes left.
May it please the court, my name is Jason Creasy, Dyer County Bar, representing D&S Motors and Mr. David Peebles. First thing that I would just note is the vast majority of things Ms. Toomes had to say are not in the record. Ms. Toomes did not file a transcript. There is no statement of the evidence. There is no compliance whatsoever with Rule 24. She also didn't have the statement that she wasn't going to do those things, which is also required. That being said, the only facts that we really have in the case that's in the record is in the judgment that was filed March 21st, 2002, where Judge Neal himself crafted the order. There were several people testified. Ms. Toomes testified, Mr. Peebles testified, Chris Kelly testified, and Mr. Peebles' mechanic testified. Some of the facts are easy. She did purchase the vehicle, as you can see in the judgment. It says what she paid for it, paid a purchase price. There was a finance charge. She did timely make her payments. Her vehicle was vandalized. Her vehicle, then she took it to Connell's. The insurance adjuster went to look to see what was wrong with the body of it. There were some mechanical problems. Connell's Body Shop didn't have a mechanic. They needed someone to look at it. The insurance adjuster and Connell's wanted someone to look at it. They contacted Mr. Peebles. He didn't contact them. He said he had a mechanic, so the insurance adjuster, and Connell's, which were both agents of Miss Toomes, said to have him have his mechanic at no charge. He looked and determined that it did in fact have sugar in the gas tank. Once that happened, the testimony at trial, which is also listed in the judgment, I believe it's paragraph 12 of the judgment, said that he contacted Ms. Toomes. She was reluctant at first, but then she agreed that she was in fact going to have the vehicle totaled out. Once she told him that she was going to have the vehicle totaled, he contacted Mr. Peebles. Mr. Peebles didn't tow this vehicle. D&S Motors didn't tow this vehicle to Memphis. It was the insurance company had it towed to Memphis. It sat there for a long, long time and accruing fees. The truth of the matter was, the insurance adjuster testified, $7,976.64 they were going to pay her. She did in fact still owe $6,200 and some change to Mr. Peebles. She would have had the entire lien paid off and had $1,700 in her pocket. She was upset that that wasn't the case, but as Judge Neal specifically found, He found that under well-established principles of agency, that Mr. Peavyhouse was relying upon her insurance adjuster, who testified that she said it was okay to do that, and he went and picked it up pursuant to Cannell's, who said that they needed a mechanic to do it. He charged her nothing. He did this as an accommodation to her. So she still had the opportunity, by the way, on the trial date, the appellate trial date in the court, circuit court down there in Lauderdale County, to still have the vehicle paid off and get a check that day. Still, it continues to accrue fees. The thing that's interesting to me is the law is pretty clear. We rely upon the presumption of correctness of the trial court letter level unless there's something in the record to preponderate against it. We don't have a record. There's nothing to preponderate against. Unless there is a clear error of law, which there is not in this particular case, there's nothing for this court to entertain. I'm sorry that she's upset that she doesn't have her vehicle. She could have told them, I don't want to have my vehicle totaled, and they never would have went and taken it. The only facts in the case is what's set forth in the judgment, and the only conclusions of law are set forth by Judge Neal in the judgment itself. She still had a contract she signed. She still owes the money to Mr. Peavyhouse. The thing that's interesting to me is to say that Mr. Peavyhouse had dollar signs in his eyes. He still hasn't been paid for his vehicle. Do you not think he would have much rather have had his payments than to wonder whether he'll ever get paid? Because now there's a mechanic's lien down there, someone holding $3,000 on it. Now, even if the insurance company pays, he can't even be made whole. Why in the world does that make sense? It doesn't. And so because there is no transcript of evidence, no statement of evidence, there's really nothing for this court to entertain except for if there's a clear error on the application of law. Do you guys have any questions? Thank you.
Ms. Toomes, you have 5 minutes.
I did not, in order for somebody to say they agree to total a vehicle out, it had to be paperwork signed that you agree to total your vehicle out. If they needed a mechanic and he didn't have a mechanic, all he had to do was pick up the phone and call me and say, Miss Toomes, I don't have a mechanic. He told me to bring the car, get the car. He had when I called him on the phone, the body shop man, he said he was a tow truck man was standing right beside him. I gave him my address. I told him it wasn't running. He said, yeah, it don't matter. I can paint it or whatever. And then I'll call you when I get done. The vehicle wasn't running when I put it in the shop. And I didn't sign no paper to total my vehicle out. Like I said, all this was done behind my back. And I did not know what the vehicle was until the last trial date. They didn't tell me I would get no $1,700 in my hand, none of that. They said every dime of it would go to David Peavyhouse. I was making, then when the next payment came up in March, I called David Peavyhouse, try to make my payment. My next, I think it was April, maybe been April, my next payment. He said he don't have the record. I don't have the record, Ms. Toomes, it's out of my hand. So I never signed a piece of paper for my vehicle to be totaled out. If the body shop needed me or if he needed a mechanic, all he had to do was call me. I would have moved my vehicle instead of them tearing it down, seeing what's sugar in there, not letting me see it. Everything was done behind closed doors. Breached contract. I wasn't behind. He stated that up here. I wasn't behind. I was paid up with my payment, insurance, and all that. That's my argument. I just want my money back that I put in the vehicle. They took it from me, took it to, or had it sent to where they wanted to go, with Coparts. Well, because I didn't know where it was to the last court date, Coparts. And they charged me $3,000 to get my vehicle, and I didn't send it there. That's unnecessary money. I don't have that kind of money. $3,000? $3,000. I didn't send it there. It could have been in my yard for the insurance adjuster to come and look at it and see about it. It could have been in my yard. My argument is the last what I'm gonna say it wasn't behind. I didn't need their help. They want their help. The last judge said he took it as they were trying to help me. I didn't need their help, didn't want it, didn't ask for it. That's it.
Thank you, ma'am. All right, we will take this matter under advisement and attempt to render an opinion as quickly as possible. Thank you. May call the next case, Ms. Angie.
Lexington Charter LP